ways.
Yeah, well, if you redefine one word, you have to redefine other words. And so there were lots of warnings that if we redefine the word marriage, then other words would be redefined. And unfortunately, I think it's been accelerated and far more aggressive than we could have understood at that time. But the word woman has been redefined. Child is now a mature minor. And words like violence and vilification and discrimination have all been, especially for those on the conservative side, have been weaponised. But the left seem to get away with whatever they like.
They do. And words like mother and father are also being erased as part of this agenda. So there's been far-reaching consequences, despite our attempts to warn people back in the 2017 marriage plebiscite. But we won't get. Let's stick on this issue. So you and Binary started campaigning about men playing on women's soccer teams. You were under an apprehension of prevention of violence order as a result of that visit from the police.
I will say it was denied first in the local court, but on appeal, that player was successful.
Okay, so just unpack that for people who don't understand the legal process.
There were three applications, 2 different players and an official from Football Australia. The Football Australia official pulled out before it went to court. The second one went to court, but they pulled out on the day. And the third one went to court to hearing. It was denied, but that person appealed and then was successful. And so I'm under a 2-year apprehension of violence order. I've never named that person. I've never met that person. I've never been to that person's games. I've never asked anybody else to go to the games. Yet somehow taking that image from the public domain, from their own football club, reposting it has been defined as violence.
So you taking an image off a public social media platform, reposting that, as people do every day, and making some commentary around a contested issue of public policy, got you in hot water, and you have an apprehension of prevention of violence order against you standing to this day.
Yes.
So one failed, one was withdrawn, but one has been upheld.
Yes.
And you've not physically met these people, you haven't physically touched them, you haven't threatened them.
Nope, haven't named them.
Haven't even named them.
No.
You just posted some commentary saying these are men playing in women's soccer.
I was very offensive in saying that why is a bloke in a frock?
Why is a bloke in a frock?
Which is a factual statement.
That's right. And that's what got you an apprehension of prevention of violence order against you. Is this Australia?
Apparently so, but it's not the Australia that you and I grew up and love and are working so hard to defend.
Yep.
It really is mind-boggling that that this can be weaponised in such a way. You can't say the names.
I can't say the names. I can say the names, can't I?
I don't know. I can't. If you do it, I can't repost.
Okay. You can't repost the podcast.
We can beep it out.
Yeah, we can work on that.
But no, if I repost, I cannot repost anything that identifies them in any way.
Wow. Okay, so that was the apprehension of prevention of violence. Then the vilification action came later. Tell us about how that happened.
It wasn't much longer. Sorry. It was first, they applied under the anti-discrimination laws in New South Wales, so it had to go to NCAT, the New South Wales Civil and Administrative Tribunal, which you know QCAT.
I do, yeah.
But because I'm a registered third-party political campaigner, part of our argument was that there is an applied freedom of political communication in the federal constitution, so that's federal law. So that means NCAT were not the right jurisdiction. So that was dismissed from NCAT, they refiled in the local court, and that's where it has began and has progressed.
That's interesting. So NCAT didn't want to deal with constitutional issues, and again, for people who might be following the law, the implied freedom of political communication was something which the High Court established. Established through the High Court through a ruling. I can't remember the exact case, but that case was a landmark case which is now routinely used to uphold freedom of political communication, freedom of speech in this country. And if people talk about freedom of speech in Australia, it's generally that implied right of political communication as established by the High Court because they found that in the Australian Constitution. But that hasn't helped you, firstly in NCAT and nor in the local court, and now it hasn't helped you in the New South Wales Supreme Court.
No, they've, there's a lot of technical arguments, and I won't even claim to understand all of that, all of those technical arguments, but they're basically claiming that there isn't a protection because I named or identified. So another player I've named once, but I took a screenshot from where New South Wales Football had named them, and note they're saying that the vilification is outside of
Interesting.
That.
So you were sued under the New South Wales Anti-Discrimination Act, as you mentioned. That's similar to the Queensland Anti-Discrimination Act, which I've been sued under by 2 drag queens. That's another case for another day, but it's essentially very, very similar legislation. There's not a lot of difference between the two. So it's, and I can't remember the wording from the New South Wales Act, but it's all around inciting for ridicule, hatred, that sort of thing.
Yeah, that's right.
And so you've been found guilty of inciting hatred. So essentially these are laws which are designed to protect people's hurt feelings.
Absolutely. And how do you measure someone's hurt feelings, and why are their hurt feelings more important than mine, or the girls on the soccer field, or the ones in the change rooms who have to endure that humiliation? And these protections are only for one small cohort of people. They don't protect everyone. And in this case, they're protecting men who wish they were women instead of women. And that's really disturbing. It's very difficult. And they've really weaponized, the activists have been very clever in these laws, because not only have I been targeted and found guilty of hurting feelings that are not measurable, the damages awarded are not measurable, nothing's measurable about this, but the policymakers in sport in particular have been able to weaponize that to say to all the players, coaches, officials and parents in these sporting codes, don't you fall foul of the anti-discrimination laws. So every woman who speaks up gets penalised, or anyone who stands up in the defence of women in this sport area, but the men who wish they were women have every protection in the world.
Yep. Did the Federal Sex Discrimination Act come into your case at all?
Not so much, but what it would have done for us had sex been defined would mean that you can mention not being women's sport, because there's a definition then of what a male...